we would probably need to file a request to set aside.
Okay, Your Honor.
And
we did just get hired on the case recently, so we haven't had a bunch of time here, but
all right, I'm just going to process it in the ordinary course of things. And I mean, Paige, do you know why it's scheduled? You know how it got on? If not, that's okay. Just say you don't know.
In our notes, it says that you requested it.
I can't see.
It's just in our calendar note.
and like I said, Your Honor, I do notice on December 9th, there was an unreturned ruling where my client didn't get notice of the ruling. And then subsequent to that, the final documents have been filed, and I'm sure that was concerning that there wasn't any notice that was received by that. But we do intend on filing a motion to set aside that.
Oh, I do know why this one was set. All right. Now that there's counsel on both sides, it probably will help things. But let me go to something real quick here. And I did have a note. Give me just a moment. And it will result in me not signing the proposed order, at least for now. Let's see. All right. The reason that I didn't sign when they were submitted, I reviewed them, and it wasn't notice issues that had caught my attention. The thing that caught my attention was even in a default situation, the court is required to enter equitable orders, and I can't. Even in a default, I shouldn't do anything that doesn't appear to be equitable. There were a couple things in there that appeared to the court to not be equitable without an explanation. The division of debts and alimony appeared to be weighted a little bit more one way. Another problem was there was $22,000 in marital money that the petitioner, there was an allegation that someone spent on a paramour, and it awarded $22,000 to the other party. That would appear to not be equitable because without further explanation, if someone spent $22,000 in marital funds on a third party, half of that is theirs to spend, the other half would not be. And so the award, without another explanation, the award would seem to be $11,000 of marital funds being reimbursed to the non-offending party rather than 22. So that didn't appear to be a logical split or resolution to the $22,000 spent on allegedly spent on a paramour. Additionally, alimony in the proposed decree was $4,000. Even though when I said it after having a hearing, I said it somewhere in the neighborhood of $2,000. And so after I'd heard the evidence, I determined that an alimony was $2,000, and yet in the deed becomes $4,000, and that may be appropriate, but just on the face of things, I couldn't determine that doubling the alimony was equitable in a default. And again, there was a request to give the respondent a truck and have the petitioner pay for it, and on the face of things, I couldn't find that that was equitable without further explanation. So I was going to ask for comment on those and ask for explanation today. Now that counsel has intervened, I know, Mr. Casperson, how those were my questions, and I don't know, you could provide in right. I don't know whether we want to hold a hearing, and you could explain to me why $22,000 and $4,000 in alimony and so forth, or you can just start to work with Mr. Hoagland and we can move forward that way. I don't know how you want to try and resolve this.
Well, Your Honor, my thought is that with respect to like the balance of the 22,000, et cetera, that may be something that the court needs to hold a hearing on. But with respect to the 4,000 in alimony, my understanding was after the court issued the order setting aside his pleadings as a sanction, and allowed my client to proceed with default proceedings, it would proceed on the default based on what she had originally asked for. And what she had originally asked for was the 4,000 in alimony, which is why that's there.
Yeah, and that's understandable. I just need to make sure that whatever I enter is equitable. And I couldn't tell from the face of the pleadings, and that's what caused the question. Is when I had heard the matter, I had decided 2,000 was proper, and I'll grant that 4,000 might be more appropriate based on a deeper dive into the evidence. But at least based on the evidence that I had at the time, I had ruled that 2,000 was the amount, and then to see that double, I was concerned that I was about to enter an order that was not equitable. And so that's what slowed me up. So let's do
I
this.
do remember that the court did not actually hold a hearing on the temporary orders. It was another default issue.
Was it a proffer? 'Cause
There was
it's
not even a
so-
proffer. There wasn't a hearing. The court just ended up entering the order because there was no.
And was that the amount, was that 2,000 the amount you sought that day?
The 2,000 was the amount I think that we had requested in our motion for temporary orders.
Perhaps, Your Honor, we just need to maybe schedule a Rule 55 hearing, and in the meantime, we'll file our motion set aside.
Just a second, just looking at the record here. Well, I thought I'd held a hearing because I did at least make some findings. I actually have written findings that were entered on March 19th, 2024. And I assume those had come from, I must have just taken it from the pleadings.
Yeah, I think what happened is after the Rule 7 timeline had expired, I requested us to submit.
Okay. Yep. And so I must have taken a look at what was pled as fact in your motion, and then based on that, made some findings and granted some alimony. All right, this is what I'm going to do. Mr. Hoagland, go ahead and file your motion to set aside the default. How soon can you get that done?
7 days, Your Honor, please.
All right. All right, and then a response and a reply, and
Your
also,
Honor, I do need to speak with my client as I think I need to confirm whether she wants to continue to have me represent her at this point.
got it.
Based on the default, which is so I just need to talk with her, and if we can work something out, then I'd be happy to respond to that motion. Otherwise, I may need to do a notice of withdrawal.
All right. What I'm going to do then is Mr. Hoagland can file his motion. You make your determinations along with your client, Mr. Casperson, and then I'll deal with the motion as it comes. And then if the motion is denied, I'll figure out what to do about maybe holding a hearing and answering these questions on parts of the decree of divorce, and then I can enter it if I haven't set it aside.
Understood. Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Are we excused?
Yes, thank you very
Okay,
much.
I wasn't sure.
No, I apologize for not saying so. And it's hard to tell on video. you know, there are none of the normal cues that you get in a
Right.
courtroom. So thank you, Mr. Hoagland, for being here today.
Thank you.
All right.